Good morning.
In unison, good morning, Your Honor.
Let's see. There was an issue you wanted to address, counsel?
Yes, please, Your Honor. Thank you, Your Honor. I was informed by the prosecution this morning that they want to call Cindy Montgomery as a witness. As the court may recall, the court essentially disqualified Miss Montgomery last week because she's going to assert a Fifth Amendment privilege on certain issues related to a secret taping of Mr. Jackson on a plane. The prosecution informed me this morning after I got to court that they have decided to grant her immunity. This is a surprise to the defense, and I was not prepared to examine her today. I have materials on Miss Montgomery that are not with me today, and it would be prejudicial to the defense for them to suddenly decide to immunize her and call her without us being aware of that. The second issue, Your Honor, has to do with a witness named Hamid, who the prosecution intends to call today. We were given proper notice that he was to testify, but we were notified last night by Prosecutor Auchincloss that there is a tape of an interview that we have not heard and certainly have not had a chance to transcribe. So because we have not been able to do that, we'd request that Hamid not testify today. I am told by Ms. Yu, who spoke to Mr. Auchincloss, that the tape is apparently not that lengthy, but we could not transcribe it in time, obviously, and I would need that for cross-examination. Based upon the information given to Ms. Yu by Mr. Auchincloss, there could be some significant information of value to us in that tape. They're the two requests, Your Honor.
Your Honor, I'll go ahead and address the Hamid issue first. Mr. Nicola will talk about Miss Montgomery. Mr. Mosley was interviewed on Saturday by myself and Detective Roble, and he gave us information on 4 points, basically that were summarized in 4 sentences, that I provided to the defense yesterday. Detective Roble recorded that conversation on a digital recorder. He came back to Santa Maria yesterday and downloaded it and made a CD copy of that. And yesterday afternoon, when he had finished that, we contacted the defense and tried to set up a meeting place where we could provide them with that tape. That didn't work out. The evening kind of became. It became somewhat late and Miss Yu said she couldn't make it to deliver that document, or that tape. I also provided Mr. Sanger an email with a copy of the 4 bullet points and I told Miss Yu yesterday the substance of those 4 points. So that's where we stand. Mr. Mosley is a witness that, probably our lengthiest witness today. So he was anticipated to take up most of the day. And I'll just say that the discovery was certainly timely in the fact that we turned it over as soon as we obtained it.
All right.
Good morning, Your Honor. I filed a declaration, a motion for reconsideration, and had those documents served on the defense by fax on Friday morning, and we filed it with the court Friday morning, as well, with respect to Ms. Montgomery. And essentially in the declaration I believe I laid out that we received late notice on Wednesday that Ms. Montgomery would assert the Fifth on Friday, or on Thursday, excuse me. We didn't have time to contact the U.S. Attorney and see their stance. On Thursday, after the court's ruling, I was in touch with both Ms. Montgomery's attorney and the U.S. Attorney. A decision was made at that time to offer use immunity for Ms. Montgomery since she was claiming the Fifth. And upon hearing Thursday afternoon that everybody was okay with that, including the U.S. Attorney, I filed my motions as quickly as I could Friday morning. I know we faxed them to Mr. Sanger's office. I have no knowledge whether he received them or Mr. Mesereau did, but we did file it, and there is a proof of service on file.
I see that we have 6 pending matters and then I was handed some more material just this morning. So we just may need time to sort this out, Your Honor. I think we're all trying to do this as efficiently as possible. On the Montgomery issue, we received sometime on Friday, and I don't think it was in the morning. I didn't see it until the end of the day. Of course we were not in session, so it was sent to me. But there was a motion to grant her use immunity, which, as I understand it, is something that the people are going to have to apply to the court for, and then the court has to determine whether or not to grant it, and the witness has to decide whether or not to testify based on use immunity, because there's a question as to whether or not this court can bind the U.S. Attorney. I heard the prosecution just say something about being in contact with the U.S. Attorney, and my recollection is, and it may be faulty, that was not concluded as of the time they filed their papers. The papers indicated that they were intending to make the motion, but there was no indication from the U.S. Attorney that they were going to abide by any grant of immunity that this court made. So that is an issue that obviously needs to be heard, and there's several parts to it. Our part, whether or not the court grants immunity. I mean, we're not here to argue one way or the other on a grant of immunity. The court can do that based on other criteria. As far as the Hamid material is concerned, I did not get the 4 points. I believe Miss Yu got the 4 points just as of the end of the day last night. We got the tape or the interview just this morning, so obviously I don't know how long it is. If it's an hour long, we need an hour to listen to it. We have not heard his most recent interview, so I don't think that we can proceed with Mr. Mosley without having an opportunity to hear the latest interview or, take some other. I think that's all we can do is hear it before he testifies. I would indicate that, just so we're all on the same page, if I may, Your Honor, quickly, the other matters that are pending would be the Mark Schaffel matter, which I think the court has. I was given some new material for Exhibit 420 by the prosecutor just this morning, at 8:30, which is one of the exhibits that we have objected to, and so there will need to be a hearing on all of that at some point. And I don't know if they intend to call him later today or tomorrow or when, but before he's called. That was a matter from last week that has been carried over, and we'll need to have a ruling on that. And then we have the people's motion to present the testimony of Alexander Manchester, to which we object, and we filed an objection on Friday. And by the way, we filed our objection, I think the court has it, on Thursday, on the first motion I addressed, which is the Schaffel exhibits. We addressed just now the Cindy Montgomery issue of immunity. The fourth one would be a motion by the prosecution to present testimony of Debbie Rowe. We filed an opposition, that was received Thursday. We filed an opposition Friday. I take it the court has that. And then 5, there was a motion for reconsideration of admitting some material the court had excluded. That motion was filed on Thursday, and we filed our opposition on Friday. And then the last thing is there was a proposed jury instruction on Chris Carter's taking the fifth that we had discussed on Thursday. The court had discussed that and said we should present something. We sent that to the district attorney's office on Friday for review and comment. We received no response, so we filed our proposed jury instruction this morning for the court's consideration, and I gave another copy to Mr. Auchincloss. So I show those 6 matters as still pending, in addition to anything else that might come up here.
I didn't see the proposed jury instruction. Did we get that? I haven't seen it.
We wanted the prosecution to have an opportunity to respond, so we gave it to them on Friday. We just filed it this morning, and gave it to your secretary, Ms. Wagner, this morning, I think 15 minutes ago.
Judge, I wouldn't worry about it. Mr. Carter is not going to be testifying.
Okay, I won't worry about it. Laughter.
5 matters, then.
On the issue of the Attorney General, who spoke to the Attorney General on the use immunity?
The U.S. Attorney's Office, Your Honor, and Cindy Montgomery?
Yes.
I spoke to them. They are not offering her use immunity. They didn't oppose us offering use immunity. Our contact with them is merely a formality between offices.
What rights does that give her with them?
Well, I believe that a state court's grant of use immunity under the legal standard that we set forth in our brief covers her in federal court. They're not allowed to use her statements, her derivative evidence from that against them. Her attorney is here today, and he would, of course, oppose her being compelled to testify on that very basis. But we served him as well with that motion. He won't contest that. I spoke to him this morning. And whatever the court's ruling is with respect to that, then that's the court's ruling.
Is he here right now?
He is not. He's upstairs. Shall I bring him down?
I think he should be here if we're discussing his client.
Certainly. It will be just a moment, Your Honor. Your Honor, do you wish the witness to be in here as well?
Yes.
Your Honor, they are present.
All right, just a second. All right, on the testimony on Cindy Montgomery, is counsel for Miss Montgomery present?
Yes, I am, Your Honor. Bob Moore, good morning.
Mr. Moore, the issue that I had talked to the district attorney about before I realized you weren't in the courtroom was what the U.S. Attorney's position was on your client's use immunity through the state court.
I don't believe he's taken a position.
What's your position, then?
My position is if she testifies here, she's exposing herself to prosecution. I'm not saying a crime was committed or that she was involved in it, but she might say something that's incriminating.
Is there any protection under the federal court system once a use immunity is granted here?
The people have cited a couple of cases, which perhaps support that. However, I'm concerned about the language in the code, 1324. It says, and I quote, the court shall order the question answered or the evidence produced unless it finds that to do so would be clearly contrary to public interest or could subject the witness to a criminal prosecution in another jurisdiction. And I think that language is meaningful. We have the federal jurisdiction. If a crime occurred, it may have occurred in Los Angeles County. It may have also occurred in Riverside County and in Las Vegas. And those are additional jurisdictions which have not been addressed.
Isn't the use immunity provision clear in terms of prosecution under California law? I mean, we're really one jurisdiction under California law. It's the federal jurisdiction that I'm concerned about.
And so am I.
There's no federal statute similar to the California statute that covers this?
1324, do you mean? I'm not sure, Your Honor.
Have you yourself discussed it with the U.S. Attorney's Office?
Yes, I spoke with him on Friday. And he took no position, which leads me to believe that there could be a prosecution down the road.
All right, thank you.
Thank you, Your Honor.
May I address the court on that legal issue, Your Honor?
Yes.
May I borrow your brief?
Sure.
Your Honor, I also left the papers I filed on Friday upstairs. And Mr. Moore has allowed to let me use the one I faxed to him Friday. Your Honor, we believe our authorities are directly on point with respect to this issue. The Supreme Court ruled quite some time ago that the Fifth Amendment privilege is of constitutional significance, obviously. And immunity from prosecution for a witness who's compelled to testify under a grant of use immunity or derivative immunity or even transactional immunity transcends between the state courts and the federal courts. The case is absolutely clear about that issue. And when the Supreme Court looked at the federal statutes, they analyzed them within the context of one jurisdiction granting use immunity to a witness who may further be subject to prosecution or an investigation in federal court. It was very specific to that. And Congress has passed other statutes which are not inconsistent with California law. With respect to the California courts, they've been following the Supreme Court line of cases now for quite some time. The case in particular was Nelson, and the fact pattern in Nelson is fairly identical to the one that we have confronting us in here. A witness believes that part of their activity with respect to what they may testify to could subject them to some kind of prosecution federally. And the Nelson court ruled that because of the waterfront case, Murphy versus Waterfront, the issue has been well settled. The same kind of fact pattern, a witness in state court testifying to something they're worried about in federal court. And the Nelson court upheld the contempt order for those witnesses refusing to testify. So we believe that we're on pretty firm ground here. And we'd request that the court sign that use immunity order.
May I respond briefly, Your Honor?
Yes.
As I mentioned earlier, to the extent that if the crime occurred, it may have also occurred in the state of Nevada, which is a separate jurisdiction. And the language in the code says if you believe that the prospective witness could be exposed to prosecution in a different jurisdiction, that's a different jurisdiction. Federal court is a different jurisdiction. The people have cited cases that seem to indicate, and they're somewhat old, but indicate that immunity would be respected by the federal court. They cited nothing to say that the state of Nevada, if a crime occurred there, is bound by the immunity you might give her today. Thank you, Your Honor.
Do you want to address the Nevada issue, counsel?
May I, Judge? The United States Supreme Court authority is binding on every court in the country, whether it's in Nevada, Alaska, or California. The waterfront holding is good law and has been for, I believe, nearly 40 years. And part of the reasoning, the broad reasoning that the Supreme Court gave it back 3 or 4 decades ago, I forget the exact date of the publication of that opinion, was that to require every jurisdiction within the umbrella of the United States jurisprudence to grant use immunity before any prosecutorial agency could use the testimony of that witness in their case is unduly burdensome on government in its most legitimate function, which is the prevention of crime and justice. So given that being the state of Supreme Court law in this country, we believe that Mr. Moore, if charges were filed against his client, based on anything she may say from this witness stand under compelled testimony by the court, he should have no problem whatsoever avoiding that evidence from being used against her, if, in fact, it does incriminate her for something. That's all speculation, but we understand the statute invites a small amount of speculation with the court. We believe that your grant of use immunity compelling her to testify will preclude any jurisdiction, including Nevada, although I can't cite a case aside from the Supreme Court case that we cited previously, from using that testimony or any derivative evidence from that against her.
There's one area of the law that concerns me if I compel her to testify, and she testifies, and the law is that that testimony cannot be used against her, which I think that is what the law is. What is the law in regards to impeachment in the federal court? If she testifies and testifies contradictory in a federal proceeding, is the testimony that was compelled here admissible for impeachment in substantive purposes against her?
Your Honor, my understanding of federal law is unless it's a voluntary statement, she can't be impeached in a federal court. It cannot be used against her in the federal court.
They can't hear you in the back.
I'm sorry, Your Honor. I thought I was speaking up. The use immunity law essentially and intellectually merges all the courts. The Supreme Court fails to see the distinction between any jurisdiction. So essentially a grant of use immunity makes that statement or any use of it, even impeachment purposes or getting a search warrant based on the statement that was given in court, completely untouchable. It cannot be used, period. It's not a voluntary statement. It's a compelled statement. And it's protected under the U.S. Constitution according to Waterford, Sic. It cannot used against Miss Montgomery in any fashion, by anyone.
All right. Anything you want to add, counsel?
I'm not sure that's an accurate statement. If she were to say something inconsistent, it could be used. It's my opinion. Perhaps I'm wrong, Your Honor.
What do you base your opinion on?
Well, I'm kind of shooting from the hip right now. It's a question I didn't expect. So I apologize.
That's called lack of authority.
Perhaps. No authority I can think of at the moment, though. And with respect to counsel's statement earlier about the federal case law he cited governing all the states, what the case says, in Daly I think it says that the testimony given in state, compelled testimony given in state court cannot be used in a federal prosecution. That's what it says. Doesn't say it can't be used in a federal prosecution or in any other jurisdiction.
All right. Thank you.
Thank you.
Let's take up the motion to present testimony of Alexander Montague.
Just before I leave, Mr. Sanger has been kind enough to give me a case, Harris versus New York, that says that impeachment can be used.
Do you have a citation on that?
No U.S. Supreme Court. I'm sorry.
That's the old Harris case. Laughter.
Yes, Your Honor, the old Harris case.
Yes.
We all know it well.
Maybe you'd like to run out. We have a law library here. Find it, and come back. I'll withhold any ruling until you find that.
I will do my best.
Your Honor, the motion is a motion by the people to present the testimony of Alexander Manchester. We've outlined in the brief what it is we expect that Mr. Manchester will be testifying to. The relevance deals with three specific aspects of his testimony. First, he'll be testifying as to dozens and dozens of telephone calls that were made by the defendant to his child. This was back in, I believe, 1998 or 1999. I don't recall which, at the earliest stages of his becoming acquainted with this child. Telephone calls that were made all hours of the day, all hours of the night. And that testimony is entirely consistent with the testimony of both Gavin Arvizo, his mother, about the telephone calls received by Gavin, as well as the testimony of June Chandler in terms of the level of obsessiveness with which the defendant pursued a relationship with her child, Jordan Chandler, back in 1993. In that regard, the testimony of Mr. Manchester is entirely corroborative of those three witnesses. Secondly, he was prepared to testify to a visit that he had with Mr. Jackson at Neverland Ranch where he was in the theater and lost track of his child and Mr. Jackson. For an hour and a half he spent looking for his child, and eventually found the child up in Mr. Jackson's bedroom under circumstances outlined in the brief. That, plus his statements to Mr. Jackson thereafter complaining about that particular event resulting in Mr. Manchester being physically confronted by a couple of Mr. Jackson's security people. And the notifying Mr. Jackson of that particular event certainly places Mr. Jackson on notice of the fact that staff at Neverland have been and continue to be vigilant in their protection of Mr. Jackson to the extent of using violence and threatening violence. Specifically, Mr. Manchester was threatened that harm could come to him and his family from fans in a manner that is entirely consistent with the threats that were given to Janet Arvizo. We believe that those three specific areas of testimony are relevant for purposes of corroboration and are not so uniquely remote in time from the events that took place in this case, and are right on point in terms of the types of testimony given by a number of witnesses in this case. Submit it.
We filed a brief response to this, and I think we really covered it. I mean, the fact of the matter is that this is offered as 1101b evidence, not as 1108. It obviously could not come in under the court's prior rulings on 1108. It is a big stretch on all of those points to say that this is conduct that would qualify under 1101b. It is extremely remote in time. This is a witness who has been, in essence, clamoring to be a part of this case. And there are people like that, and they should be viewed with some distrust. This man's child was interviewed and consistently denied that anything inappropriate had happened. There's no evidence that anything inappropriate had happened. And yet we have this man, who is a self-proclaimed, perhaps actually is some sort of royalty down the line, who just insists he wants to be a part of this case. And I don't think this qualifies under any stretch of the imagination. It's way too remote in time. Despite Mr. Zonen's rhetorical efforts to make it similar, it isn't similar. The fact that some security guard did something in the 1990s, and Mr. Jackson may or may not have been aware of it, doesn't mean that it can be used against Mr. Jackson in this case. And it really comes down, in essence, to one thing. And I was almost just going to submit it without saying anything, but I want to.
But you just couldn't do that.
I couldn't do that. Now I'm trying to justify it.
I knew you couldn't do that.
Some of these last-minute motions share something in common, and that is sort of a desperation to come in and dirty up the case and make Mr. Jackson look bad as opposed to really bear on something that is actually relevant to this case. The court has now heard the testimony of Janet Arvizo and some of the other testimony that makes the story of the complaining witnesses in this case highly improbable, to say the least. And it just isn't right to allow the government to come in at the last minute and try to pull in strings on things that are not relevant and are not proper 1101b or 1108 evidence. So I'll submit it on that, Your Honor.
Mr. Manchester, it's our desire that Mr. Manchester be a witness in this case. It's hardly Mr. Manchester's desire. He'd be happy to be left well enough alone. He has been on our witness list from day one. He was subject to an interview at the earliest stages of this investigation. And we're talking about within weeks after the execution of the search warrant at Neverland. This information has been turned over to the defense. It's been well over a year, probably closer to a year and a half, that they've had this information, or longer. We certainly indicated that we intended on calling him from the very earliest stages, if not just the investigation, but certainly the trial as well, and he was on our witness list from day one. Now, this motion is being filed at this stage because it is corroborative of the testimony of other witnesses, and it was appropriate to wait and see how they testified before doing this, but nothing comes as a surprise. These materials and reports were turned over to the defense early on. And it is corroborative of all of them. It does come in as well under 1101, but also it is, under California's Constitution, that all relevant evidence is admissible, and this is clearly relevant evidence. It's corroborative of each of the three different witnesses. Submit it.
All right, the court's going to deny the motion to introduce Alexander Manchester's testimony. It doesn't comply with my previous ruling that there had to be some connection of evidence of grooming activities with actual molestation, and there's no consistency in the other parts of it that would lead the court to admit it under 1101. So that motion is denied. The motion that, on the admissibility of Gavin's statement to Chris Carter, that's no longer an issue, is it?
You ruled on that already, Your Honor. You ruled that it was admissible, but it's no longer an issue.
I think I said I intended to admit it at the end of the court day, didn't I?
Yes, Your Honor.
But I didn't want to rule out a statement from someone, or an argument if someone wanted to make it.
Chris Carter.
It's not necessary, Your Honor.
It's not necessary.
It's not at this point.
I just wanted to be sure. Okay. And the issue on the admissibility of the defendant's adult books from 1993 seizure, have you responded to that?
Yes, sir, we filed something on Friday on that.
Do you wish to add anything more to that? Either side?
I'm sorry, was the court addressing the prosecution?
Yes.
Only to the extent of saying that it is our recollection that the court had indicated that the court would reconsider the issue with regards to the 93 seizure subject to resolution of the 1108 motion. That, of course, has been resolved. These books were seized. We are only asking to introduce 2 books of all the items that were seized during that period of time.
Where are those books?
We have them here in Santa Maria. We could have them before the court within an hour, if the court would like to see them.
I'd like to see them.
All right, we'll make arrangements to get them over here to you.
And, Your Honor, your comments suggest that you don't have the opposition in front of you. Could I give you?
I don't have it in front of me. Thanks.
Let me just give you a copy.
I'm going to reserve ruling on that until I see the books. The testimony of Debbie Rowe. Do you wish to be heard on that?
Your Honor, very briefly. The facts are outlined in the People's Brief on that matter, but Miss Rowe had, virtually at the same time that Miss Arvizo was submitting to a tape-recorded interview or videotaped interview for purposes of rehabilitating the damages to the defendant caused by the Bashir documentary, Miss Rowe was doing exactly the same thing. It was also a highly scripted interview that was being conducted. And there was the virtual identical incentive for her to do so, participate in the interview. And not just participate in the interview, but participate in the interview with enthusiasm was the suggestion in statement that she would be allowed to have visitation with her children. Something she did not have at that time. That was, in part, of course, an incentive for her to participate in that interview. We believe that the fact that they used the same types of scripted questioning for purposes of conducting this interview, that her performance was the same level of over-the-top type of performance that we saw from Miss Arvizo, and the fact that the children were used as pawns to create that level of incentive is relevant in this case. Submit it.
What about the fact that the defense raises that the Maury Povich footage has not been seen by the jury?
Well, the Maury Povich tape is not relevant in this proceeding as having anything to do with her interview, except to the extent that segments of her interview are in it. We're not planning on playing the Maury Povich interview. If we wish.
How does the jury understand the context of what you're presenting?
Well, we have the interview of Debbie Rowe separate. The entire interview was about 3 hours long. We haven't decided if we intend on playing all of it, any of it or none of it.
The interview by
the Ian Drew interview of Debbie Rowe, which was done at the same time. Mark Schaffel was present, Rudy Provencio was present. A number of the people who were involved in the interview with the Arvizo family were involved in this interview as well. And a number of them were present at that time, and there was discussions about what to do and how to do it. Many of them are witnesses to those events as well, including Debbie Rowe's attorney, Iris Finsilver. But it's not necessary to play the Maury Povich film in that most of it has nothing to do with the Debbie Rowe interview. It's simply other information about Michael Jackson, his history, his life, his performances, his music, other people in his life, his father and allegations of abuse, things like that. But there is a separate video of the entirety of the Debbie Rowe interview. Only segments of it were actually shown on the Maury Povich film. But we have the entire thing on video and are able to play the entire thing if it's appropriate to do so, if it's requested by either side, if the court feels it's appropriate. Or we could do it in segments, or we could do none of it and just have testimony about it. The interview is about 3 hours and 2 minutes, I believe, in its entirety.
Counsel?
This, once again, is reaching. First of all, Debbie Rowe gave up her parental rights, which is a totally different situation than we have here. There's an ongoing family law matter that persists, even as we speak today, in Los Angeles over the relationship and her attempt to get possibly some visitation or some other benefit from that. However, we keep hearing scripted performances, and there are no scripts. The only thing that has ever come up in this case, and will be clearly shown, if it isn't already, by the time we get through, is that there were questions that were written out in advance. And anybody that does any kind of an interview for television is going to script out questions in advance, just as lawyers script out questions or question areas before they get up and ask witnesses on the stand, so interviewers script out their questions. There's nothing untoward about that. There was no scripted response to anything, despite Janet Arvizo's preposterous testimony on that. Everybody else will testify consistently with common sense that there was no script of answers. So it doesn't show a darned thing in that regard. And as we pointed out, and the court's already commented, the Maury Povich show is not in evidence. I don't think there's any way we can get it into evidence. We don't intend to offer it. And as a result, unless Debbie Rowe testifies, of course, So how is her performance on that tape relevant, as much as the prosecution would like to make it relevant? And I'm hearing they'd like to play parts of her tape, which just creates, under 352, if we even get to that point, if there is any probative value to this, it's far exceeded by the consumption of time, the confusion of the jury and the prejudicial effect. Because if they bring that in and they play even part of the Debbie Rowe tape, we'll play the 3 hours. There's no question that Debbie Rowe was spontaneous in her remarks, and it goes on and on. I think the court saw the Maury Povich part of it, where she even answers at one point, look, and she uses some term that would not ordinarily be appropriate on television, kind of laughs about it, and says, I just want to get to the point. Here's what it's all about. That is her demeanor on the rest of that tape. She is giving an interview based on how she felt at the time. However, if the court allows the prosecution to get into this, besides playing the 3-hour tape or a large portion of it, not as a threat, but because it will show the context of her answering questions in a very spontaneous fashion, we will have to get into this whole business with Ian Drew, and his fight with Mark Schaffel, and Mark Schaffel's fight with Ian Drew, and all that surrounded this. Debbie Rowe's on tape, in fact. And she surreptitiously tape-recorded conversations that she had with Ian Drew that go on for hours where she is not upset at Michael Jackson, doesn't say anything bad about Michael Jackson as far as the case is concerned. She says a few callous things, I might point out. But other than that, her focus is she doesn't like Mark Schaffel. And so she's fighting with, or working with Ian Drew to fight about Mark Schaffel. All of this will come out to show. It will have to come out because it shows the context in which she would be testifying here. She has been extremely upset with Mark Schaffel for some other reason and has had an agenda that's clear on all of her taped remarks, including the ones she taped of herself talking. It's very clear that she has some agenda with regard to Mark Schaffel that has nothing whatsoever to do with Michael Jackson. She regards him as just being pretty much a victim in Mark Schaffel's machinations. So if she's going to testify, we're going to have to bring that out. Again, it's not a threat. But I want the court to understand the context. There really is a tremendous amount of material, tape-recorded material, by Debbie Rowe and by others in the group that the prosecution is trying to present here which indicate that there are many other agendas on this case. I don't know if you get to 352 because I just plain don't see the relevance, forgetting about the giant can of worms that it would open. I just don't see the relevance to these proceedings. So I'd submit it, Your Honor.
Your Honor, all of these people are interconnected in a number of different levels throughout this case. And the court has been very good over the last number of months as we've proceeded through this trial in being able to separate what's relevant and what's not relevant and keep everybody on point, and on focus, and I think that we can do that in this case as well. I mean, the fact is that she had a scripted interview that she gave. And part of the incentive for that interview was the suggestion that she would be able to have visitation with her children. Yes, it is true that some years ago, she gave up her parental rights. She had misgivings about doing that, particularly after this indictment came down. She went back to court and was successful at reversing that decision. So her parental rights have been reinstated since then, and now the litigation that they're involved in is compelling visitation with these children. To that extent, the children have been appointed counsel and that counsel has not yet had an opportunity to visit with them, to my understanding. I don't see that that's an issue that would or necessarily should come into evidence in this particular case, except to the extent that she was promised visitation with her children if she did this video. That hasn't been given to her and is something she wanted to have. She did want to see those kids. To that extent, it's one more example of how this group of people used children as a pawn to compel not just participation in these videos for Mr. Jackson's benefit, but an enthusiastic response as well. Now, there will be obviously some level of questioning as to what's enthusiastic within reason, what's enthusiastic outside of reason. We expect that, but that's part of the give and take of the litigation process. We think that we can control, with fair measure, how far afield we go in terms of relationships between Schaffel and Ian Drew or any of the other people who are involved in this case. And at some point in time, some of these things become too collateral. And the court has been very good at recognizing that and putting the kibosh on it, and I expect that will happen in this case as well. I think that I've mentioned in the pleading, and it's worth mentioning again, her participation in this video was at the behest of Mr. Jackson personally. Initially she was contacted by Mr. Konitzer, one of the co-conspirators, but ultimately it was Mr. Jackson who made the initial phone call and brought her into this.
All right, I think we've argued every issue except the problem with the foundation of documents of Mark Schaffel, the ones seized from his office. On those, it seems to me that we have to sort of do admissibility on a case-by-case basis as the documents come up, as opposed to some of the offers are made without evidentiary. I mean, they're just that, they're offers without true evidentiary basis. I find it kind of hard just to go through and make rulings on all of them in advance.
Well, our primary foundation will be laid with the officers who seized those documents in Mr. Schaffel's home. And as I mentioned in our brief, I think that authentication will be sufficient when the court looks at each document and considers where it was found. As to putting on separate foundations for each document, those foundations are going to be primarily laid in terms of hearsay. Certainly secondary evidence is really not an issue here, hearsay and relevance in light of the totality of the circumstances of the case, which the court has before it. And most of those arguments will be handled in consideration of the evidence that is presently before the court as to how they specifically are relevant.
Well, my example would be Exhibit 401. You say Rudy Provencio will verify the signature.
Yes.
Those are the kind of items that you say are going to happen.
And that's fair.
We don't know if they're going to happen.
But there really are only a couple of witnesses left that will testify with any specificity about these documents. Mr. Provencio is one of them, so he's certainly one person who's going to figure in on these foundations. So if you'd like.
I understand the basic seizure issue that you're raising, but that's not the, that just says they're seized legally. Now you have to prove the connection to the case.
Except for.
It seems to me that you're going to be able to do that. But I'm not going to rule in advance based on your representation that that's going to happen, that they're all admissible. It's like any other evidentiary issue. It's not till I hear the actual foundation and I hear the witness that I make that ruling.
Yes. Well, I guess I'm just preparing the court for the fact that we have basically only, the first foundational step is the one which
the seizure.
Is the seizure. And we'll go from there and deal with it piecemeal, if that's the court's desires.
And that allows you to, unless you want to address something separate from that.
Let me just address a little more of a generic concern that I have, because the way we saw this, and given the fact that the court's of course very familiar with this case by now, but Your Honor has not had a chance to see everything that we've seen. Okay? So I just want to share with the court, my belief is that if the prosecution is allowed to start going down this road in front of the jury, that we're going to have a lot of wasted time and we're going to have some potentially prejudicial material get in front of the jury just to have the court say there's no foundation. We understand that this stuff was by and large seized. Maybe all of it in this segment 400 to 420 was seized by law enforcement, in one form or another. We're now told that there was a disk of hard copies as opposed to a disk of direct emails, but that was this morning. We'll take a look at that. But assuming for the moment that it was all seized from Mr. Schaffel's possession somewhere, do we go to the point where we start marking things? We have somebody like Rudy Provencio giving a lot of testimony about his alleged connections with Mr. Schaffel, which would otherwise be irrelevant, only to find out that. And I think it would be let's take a fairly easy ruling. There's a Pendaflex file label that, as I understand, it's a Pendaflex file label that says something like, "Fire's burning." How in the world could that be admissible unless it's not admissible? It just doesn't make any sense that that would come in at all. That's hearsay. We don't know who made the file label. The fact it's in Mr. Schaffel's possession in an office that he shared with a number of people, so what? It just doesn't come in. But are we going to have testimony about that and spend a lot of time? For the most part, and I think entirely really, these exhibits are based on that kind of speculation. It's stuff found in Mr. Schaffel's files in an office which the government knows was shared by a number of people during the relevant time period. So there's no way to authenticate it. And Rudy Provencio is apparently the person they're going to rely on. He's the person that volunteered to be an informant for the government, and tape-recorded conversations ad nauseum with all sorts of people that meant nothing, turned the tapes over to government. And one little thing they want to call him in here for is really speculation that somehow these documents, which he's not going to say he saw before, are probably legitimate because they came from Mr. Schaffel's stuff. And I think if the court has a chance to see that in the big picture, we save a lot of time by resolving it now. If the government had 1 or 2 or 3 things that they thought did not come within that category, then maybe we should hear that and we should focus on those. But I see this as taking quite a bit of time for no apparent reason. That's why we tried to address it up front. Thank you.
Just one final remark. This case, the conspiracy case, the evidence of the conspiracy deals with words. Just as in a drug case, the evidence in a drug case is the drugs. You find the drugs in the home of the individual, those drugs come in as evidence of the crime. In a conspiracy, we're dealing with communications between the parties, with the knowledge that the individual parties have, the relationships between the parties, the various motives that may be pushing them forward through this conspiracy, and evidence of the criminal act itself. So that's where these documents come in. And I don't think it's very genuine to say that we don't know whose documents these are. They're Mr. Schaffel's documents, found in his personal files, found with all his other files in his home, in his filing cabinet, in his office, and in his locked closet. So there's no issue as to whose records these are. And we've gone through the records and taken out the ones that are relevant to this case, showing the relationship between the parties, showing the evidence of the conspiracy and the communications, and the criminal acts themselves, the arvisos, specific involvement with the arvisos. So that's the nature of the relevance and where we're headed with all this evidence.
The attorney is not back yet on. That was looking for the Harris case? Does anyone? I'd like someone to communicate with him and have him come back in.
We could ask.
I'll take that responsibility, Your Honor.
We won't fight over that. I was going to offer. But that's all right.
Mr. Nicola has gone to get him, Your Honor.
Excuse me, Your Honor.
Yes.
We have found the citation, Your Honor, if the court wants it.
Counsel?
Yes.
Did you find your case?
I did. If the court would like the citation, it is 401 U.S. 222. Would you like the lawyer's edition?
No, that's fine.
Thank you.
What
the case says, and I apologize, a rather quick read, Your Honor, but Ms. or Mr. Harris was not properly Mirandized, and ultimately the decision is that the non-Mirandized statements can't be used to convict, but they can be used to impeach. And I think that's the holding in the case.
Well, that's the underlying case that caused me to.
Yes, Your Honor.
Raise the issue. But does the case go to the issue of immunity, or is that just the?
It talks about Miranda.
Okay. That's all right. Thank you.
Anything further, Your Honor?
No.
Thank you. Does Your Honor want me to remain at counsel table, or?
Just for a moment.
Thank you, Your Honor.
All right. The court is going to grant the people's motion and grant the request for use immunity as to Cynthia Montgomery. I do not know if I have the original document for signing of the use immunity that you provided, but do you have that, Lorna?
No, I don't. Carrie has it.
I believe Carrie has 2 copies, Your Honor. We'd request 2 original copies so that I may serve the United States Attorney in Los Angeles with that, so they're clear on that issue.
Okay.
I believe defense counsel also wanted to delay her testimony. I didn't hear the court address that issue.
I don't think they did. They wanted to delay
Mr. Mosley.
Mr. Mosley's testimony.
Also Miss Montgomery's, Your Honor. I didn't know she was even an issue. I didn't come here today prepared to examine her. If I could have a day.
They can't hear you.
If I could have just a day, Your Honor, I'd be prepared to do her tomorrow. I just didn't know it was even an issue.
They say they served you last week. They served me. Why didn't you?
Did you get it? We got it Friday at the end of the day. I was not notified of it. I got it Friday at the end of the day. That's all I can say. And
so what witnesses are you prepared to go forward on?
We have Mr. Abdul here and ready to testify. He will be the first witness, Your Honor.
How long will that be?
I'm expecting direct examination to be in the neighborhood of a half hour, 40 minutes at the most. After that, we intended to call Mr. Mosley, and then we intended to call Cynthia Montgomery, and then we intended to put on the officers with regard to the search of the Schaffel residence and the items that they took. And we felt that would take the entire day and probably not more than that, frankly, given we knew that the court was going to have to spend some time on rulings today. But at this point, Clearly we have one witness here ready to go, and that's Mr. Abdul. And then the rest is contingent upon what? The position that the court takes on the defense request. I should say we're also ready to go forward to get the officers here on the shaffle search. And we could do that during the time that Mr. Abdul's on the stand. We were going to put them after the civilian witnesses, but we can get those people here, Your Honor. So, and we would, obviously, if you told us. So those are the options available to the court.
All right, well, I think I will give the defense time that they have requested on both the witnesses so that they can hear the tape and prepare their examinations. So I'll have Cynthia Montgomery testify tomorrow. I mean, I'll put off her testimony one day, and the same with the other witness that you have the tape on.
Mr. Mosley, Your Honor?
Mr. Mosley, I'll put that off until tomorrow to give the defense time to review that. So we'll go forward with Abdul and then the officers today.
All right, we'll get those officers in here, and…
Thank you, Your Honor.
This is our counsel?
I was just going to inquire, Your Honor. Ms. Montgomery is up from Los Angeles and flew me up this morning. Can we get some sort of a time indication as to tomorrow? Would it be first off?
What would be most convenient for you, since I'm putting it over till tomorrow, to be first or later?
First thing tomorrow.
Most convenient would be to do it today, Your Honor. But not having that as a choice, first up tomorrow would be.
Can you accommodate him there?
I would say that's okay. We haven't checked with the other civilian witness, but we can do that.
Well, if you can't, let him know.
I will. I will check at the break. But as of right now, let's just assume that that is correct. We'll put her on first and Mr. Mosley second. Okay?
All right, this is the normal time for our break. We'll take our break, and then we'll expect to have the jury in at